Turn now to the next case on this morning's docket. Case number 104241, State of Kansas v. Dinh Loc Ta.
Mr. Chief Justice, Michelle Davis appearing on behalf of the appellant, Mr. Ta. May I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. The main issue in our brief is that the court entered a conviction without requiring the state to prove an objectively lewd fondling or touching, and that the state was able to obtain these convictions by misstating the law in closing argument and by misinterpreting the statute to the jury. And so,
can you
yes.
just satisfy my curiosity about something?
Sure.
Was there any effort to have this defendant examined for whether he was competent to stand trial?
I don't see that in the record, Your Honor.
Okay. So there's nothing in the record that indicates whether he had any particular mental illness or?
There was no evaluation as far as I know.
Okay, thanks.
Factually here, what was the contact between your client and the kids in the playground or whatever area that was? What?
It's outside of the Warren Theater in Wichita, and there's apparently it's
described as a public
I
understand the location.
Park.
What was the nature of the contact?
Okay, so the two young mothers and the two young children are sitting on these benches, and an L-shaped bench, and supposedly he approaches, and not supposedly, but the record says that he approaches and introduces himself, chats with the mothers a little bit. He says he was standing. The mother said that he sat down next to one of the children, and he pushed her hair behind her ear.
Okay.
According to the mothers, he pushed her hair behind her ear, and then one of them said that he was rubbing on her arm, and I think there was some maybe rubbing on a leg.
Okay.
And then one of the mothers went and picked up the child and sat with her. He went and approached the other child who was sitting next to the other mother, and apparently there was some rubbing on the arm there. One of the mothers said she saw that. And then the other mother picked that child up, and then Mr. Ta walked away.
Uh-huh.
And then the two young mothers went up to the theater because one of them worked at the theater and approached the manager and told him what had happened, and they said that they weren't comfortable with him talking to the children, and they weren't comfortable with him rubbing on the children. And the manager said, obviously wasn't outraged because he didn't go, well, let's call the police. The manager said, well, if he approaches you again, then we'll call the police. And then the two young women went ahead and called the police on their own.
Okay. Thank you.
So what we need to look at here, the starting point is the statute. And what the statute prohibits is any lewd fondling or touching of the child done with the intent to arouse or to satisfy the sexual desires of the child offender, etc. So basically it's our contention that the statute then requires a certain type of conduct, a certain type of contact that the word lewd actually is a modifier or a qualifier of the fondling or the touching. And then this court, again, the Supreme Court in the case of State versus Wells in 1977 defined what the word lewd means, and that's where we come up with the instruction that's given. I think I've seen it in just about all of these cases where the jury is told that lewd means a fondling or touching in a manner, and again, then we're in the manner. So it's talking about a touching or fondling has to be done in a certain way, in a manner, which tends to undermine the morals of the child, which is so clearly offensive as to outrage the moral senses of a reasonable person. That's not the full definition, but that's the part that I really care about. And Mr. Todd did raise this issue to the district court. He moved for a judgment of acquittal after the close of the state's evidence and then after the verdict. And the trial judge acknowledged that the acts in this case were, he called them relatively innocuous. And he said that based on the acts, which were the touching itself, that the defense would be correct in its judgment, which I assume means that there was insufficient evidence. But the judge said that the statements when you factor in the statements of the defendant, that's the critical turning point. And that's basically how the state obtained a conviction in this case, because what the prosecutor told the jury, and if you look at the beginning of the prosecutor's closing, this is on volume 4, pages 16, 17, the prosecutor says, from his words, we know that he had a sexual intent. Now, was this done in a lewd manner? Because that's really the million-dollar question here. And the prosecutor says, a lewd fondling does not require contact with a sex organ. It can be someone, which is correct, it can be someone who wants to touch feet for a sexual purpose. Clearly, this defendant was enjoying sexually the touching of the legs, the arms, the hair, the face of the girls. And then the prosecutor says that's what makes this a sexual touching. Because we know from his words that he had a sexual intent, that he was getting sexual pleasure, there was a sexual purpose. So the prosecutor then says this is a sexual touching. And then he says a sexual touching. Does that undermine the morals of the child? Is that what he's doing? Is that outrageous to you? Does it outrage your morals? So what the prosecutor's saying is that if it's a touching that's done with a sexual purpose, if it's a touching that's done for sexual enjoyment, then it's a sexual touching. And when you have a sexual touching, that then outrages. That qualifies as lewd, because it outrages the moral sensibilities of a reasonable person. So instead of requiring the touching or the fondling be lewd, what he's basically saying is that if we consider this to be a sexual touching because of the thoughts that are in the defendant's mind, then that makes it a lewd act because it outrages you. And then the defense counsel gets up and says, in her part of her closing, what we have here is a moving of a hair out of a little girl's eye, a reassuring rub on an arm, and a pat on a leg right in front of their mothers in a public park with other people around. And that all sounds good, but when you've had the prosecutor put in your mind a sexual touching, and doesn't that outrage you? Isn't this outrageous? That he's touching these girls and he's got sexual thoughts in his mind. When you have that image in your mind, it doesn't matter that the defense lawyer's getting up there and saying, this is all we have here, this isn't enough, because you've got this image of the sexual touching in your mind. And that's outrageous, and that's a lewd act.
Was there any focus? I think I understand your argument about the prosecutor combining the intent essentially with the actual physical actions of the defender, the actus reus. But was there any attempt on the part of the prosecutor to talk about the setting of this, the fact that this was a stranger in a public place who comes up and is touching these girls in a somewhat intimate way when he's never met them, doesn't know their parents? And can we factor in sort of the oddness and the strangeness of that setting and the fact that he is a stranger? Can that be factored in, and are we excluded from factoring that in by Wells or any prior definition of lewd conduct?
Yeah, I just think it's irrelevant because it doesn't meet the definition of a lewd fondling or touching. What you're saying is it may have been an inappropriate touching. It may have not respected boundaries. It may not have been something that a stranger should be doing.
But couldn't it be clearly offensive, such as to outrage the moral senses of a reasonable person because of the fact that he's a total stranger who wasn't invited up to come up to them in this public setting and starts touching these girls without knowing who they are? Couldn't that contribute to the outrageousness of it?
But the touching has to be clearly offensive. So what you're saying is that a reasonable person would have to say that a stranger touching a girl on the arm or moving her hair back is so
Stroking
clearly
her hair,
offensive,
rubbing her leg.
is so clearly offensive as to outrage the moral senses of a reasonable person?
I'm just asking, can you take into the account the fact that this was a total stranger? These women had never seen, the young girls don't know. They're sitting outside in a public place, and he comes up and begins touching these girls. Mm-hmm. Can we take into account the oddity of it, the strangeness of the situation? Does that make it, can that make it lewd conduct? I'm not sure I know the answer. I just wondered if that played into this at all.
Well, I suppose that context does have some application. I just think the difference here is that this between inappropriate touching where the mothers pick the children up and move them away because he is a stranger versus if he had done something that I think met the definition of statute, they would have been standing up and yelling for the police at that moment, and that's the difference. and the manager would have been outraged also. That's the difference between something that was inappropriate from a stranger versus something that we consider child molestation. So I think you're right. I mean, I think the context, but the context kind of also explains the mother's behavior, doesn't it? In terms of removing the child, or in terms of removing the child away from the defendant. But just
The
because
oddity of it, the strange nature of it.
right, but that doesn't necessarily make it a crime, I guess, is my position.
That answers my question.
Okay. So then we have the defense, and then the prosecutor gets back up in his second part of his closing, and the prosecutor says his words are what makes it a crime, and his intent and his sexual desires make it a crime. So again, we're getting back to this. This is a sexual touching because we know he had sexual thoughts, and therefore that makes it a lewd act, instead of that it's the touching and the fondling has to be lewd.
Is it saying that, or is it just saying that we do also have to have intent, and his words prove intent?
Well, the problem is that he just makes the words being the crime. He doesn't make it that shows his intent. And he said that earlier on, yes, his words show his intent. But then he's also using his intent to then say that that's enough all by itself. And that's the problem here. And
But if there were the actus reus, the lewd touching, without the requisite specific intent, arguably we still have a crime, because that would be a battery, a touching, a non-consensual touching in a rude manner.
in a rude, insolent, or angry manner, yes.
Yeah. So, I mean, if we have crime think in George Orwell's vernacular, we don't quite have the thought police yet, and so we don't quite make that a crime. So the thoughts aren't a crime, but in this case, the lewd touching was a requirement to make a crime.
That's our position, Justice.
Regardless of what the mindset was, a lewd touching would have been a criminal act in this case.
Yes. Yes. If it outraged the moral sensibilities of a reasonable person. But
Or if you didn't have the specific intent, it still would have been a battery under that definition.
if it was rude, insolent, or angry manner, yes. I'm not sure we have that here. Okay.
It's not rude.
Insolent or angry.
Rudely touch someone without their consent. Well, that we don't need to go there.
Yeah, it's debatable. I guess we can see it was maybe an inappropriate touching for the context, but whether it amounts to a crime, I'm not sure. So, let's see. And I think the reason that I'm really pointing at the prosecutor's comments in closing is because obviously it lowered the state's burden of proof, because the state wasn't required to prove a key element of the crime. And obviously it's our position that the trial judge in this case should not have entered a conviction against Mr. Ta. I think I have covered everything. The only other thing I wanted to point out was, obviously I think my brief says basically if the state tried this case basically saying if there was the state's theory in this case is there's any fondling or touching of a child with a certain intent, then that's child molestation. And obviously I think that's a dangerous road to go down. But I think in looking at the prosecutor's comments some more, I think it even kind of goes further than that. I think the state's almost arguing this was a lewd act, and it qualifies as a lewd act because you had a fondling or touching that was done with this certain intent. And again, that's just however you want to look at it. If you want to take the word lewd out of the statute and just say it's any fondling or touching, or if they're trying to say the statute says it's a lewd act because he fondled or touched with this intent. Either way, they're both erroneous. That concludes my argument.
Any further questions of counsel? Thank you, counsel.
Thank you.
May it please the Court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas. And I'd like to start with, I guess, the questions that we heard about whether we can look at the context of the touching to determine whether it's lewd. I'm absolutely floored for anybody to suggest that you can't look at the context of the touching. I'm certainly positive that the defendant would like us to only look at the clinical touching. He caressed my knee, it's the fact that it's an unknown person, a stranger. It's the fact that he's undaunted by the first child being taken away, and then he just moves on to the second one. That helps provide the picture of what we're talking about. I mean, I can't imagine that the prosecutor or anybody else, the jury for that matter, would be limited to just, yes, he touched my ear. He touched my ear, but I was in a public restroom, and he came up underneath the stall, and he touched my ear. Those are the circumstances of the touching.
Mr. Ishwood, my question about the context was really asking if the prosecutor focused on the context. And it seems to me that what the prosecutor focused on here was not so much the context and the oddity of it and the stranger danger type situation, as much as he basically said to the jury, this defendant said after the fact this was his intent, and that essentially his after the fact statement about what his intent was proved the lewd nature of the conduct. And I guess I was trying to find out, was there a focus also on just the context of it?
Well, Your Honor, I'd like to answer the question this way. Counsel has, in their brief, only highlighted one portion of the prosecutor's statement that she complains about. It's the only portion in that brief that has any type of keying to the record. She did bring up something else today, and I do understand that the court is to look at the closing argument and the case in the totality. But my focus in the brief was on what they complained about, assuming that by not complaining about any other portion that was okay. As I understand the argument, because I can't have it memorized, the entire closing argument, my remembrance of the argument is that the prosecutor came on and at least twice before defense counsel's closing argument keyed the jury back to the elements of the crime as they were given to the jury in the instructions, discussed the appropriate definition of lewd fondling from Wells. The comment that they complain about only comes after defense counsel's statement of, if we really come to this, you can't go to the park and say hello to a kid without getting charged with a serious crime. And I think what the prosecutor is doing in the part they complain about is bringing the jury back to reality, which is this isn't someone coming to a park and touching or saying hello to a child or simply patting a child on the knee. I don't think the prosecutor at that time is doing what counsel suggests that he was, which was he wasn't trying to define the crime at that time. Not every word out of the prosecutor's mouth can be, because counsel's argument when she came in here today was that the prosecutor misstated the law. Well, you can clearly see that the prosecutor did not misstate the law every time he spoke. The problem is that we need to look at it, the complaint in context, and when we do that, the prosecutor's not trying to define the law at the time. He's trying to counter defense counsel's improper plea to the sky's falling, you can't go and talk to a kid. That's what the prosecutor is attempting to do now at that time that they complain. And again, that's the only complaint that opposing counsel comes in here with, is this one portion, and that's what I think this court needs to direct its attention to.
Mr. Ishwood, who was the prosecutor at trial in this case?
Who was the prosecutor in our office? Justin Edwards.
Okay, thanks.
Two issues. One, whether we can survive the motion for a judgment or acquittal, and then the other issue is prosecutorial misconduct. I think that counsel has lumped the two issues together today. I would direct the court's attention to the definition of lewd fondling that was given in the case, the definition that opposing counsel read half of and then said, well, that's the part that I'm interested in. Well, the part I'm interested in is the definition of lewd fondling or touching tells you to look at the intent. It absolutely does.
But intent can't manifest the actus reus. You have a mens res and an actus reus.
That's
right?
correct.
If I shake opposing counsel's hand after the trial is over with and I have all kind of manner of bad thoughts in my head as to what I would like to do to opposing counsel, my crime think has not made that an aggravated battery when I shake hands, has it?
Well, I think that two things here. One, I'm going to have to plead ignorance on the crime think. I'm sorry.
Read 1984.
Okay.
Yeah.
Well, I'd like to focus on this case and the difference between the scenario that you just put out, Your Honor, and the scenario that is happening in this case. Is this the extraordinary case where the defendant tells us what his intent was? We don't have to guess.
No. Oh, I'm going to tell you what was in my mind. I'm going to tell counsel that, boy, I sure would like to kill you. What I'm saying is the fact that you have an innocuous touching or a touching that would not in and of itself fit within the common understanding of a lewd touching, that act is then transformed. The pat on the head or pat on the arm or the move the hair away, those acts in and of themselves would not fit the definition. If they would not fit the definition, they all of a sudden become a lewd touching because of what was in the defendant's head?
Well, Your Honor, I think that when you're talking about the definition that was given, the approved definition of lewd fondling or touching, tells you four things. It undermines the morals of the child. It clearly offensive to outrage the moral sense of a reasonable person. And then, which was done with a specific intent to arouse or satisfy the sexual desires, and then it doesn't have to touch a sex organ. The jury was instructed, an instruction that counsel says was correct, an instruction that this court has said is correct, that one of the things you can look at in determining whether a touching was lewd is an intent, if it's expressed. We do that all the time the other way. How do we normally prove an intent? We look at the actions. How do you prove an intent unless it's stated? You look at the actions. And so now we get pushback when you're having...
What were the actions here that would manifest the specific intent? Let's go the other way here. Mm-hmm. Moving the hair back, hi little girl, move the hair back out of her face, touch her on the arm and pat her on the leg. How does that, with a smile and talking friendly, how does that manifest the specific intent to arouse himself, herself, or both?
Well, first of all, I'm not suggesting that you have to limit yourself just to the expressed intent or the action. I think that, as the case law indicated in my brief indicates, you look at the totality of the circumstances. There's no need for us to isolate one thing and focus on it. As you say, a pat on the back. I don't know that it was a pat, it was a rubbing, but it was by a stranger. It was someone who was undaunted when their first victim was removed. You can't ask me to tell you what is it about this case that proves that there was enough to go to a jury and have me focus on one thing. It's the whole package. There's no need for us to focus on one thing. It's the fact that there were a number of touchings on one child by a stranger who then moves on and, as I understand the record, does the same thing to another child.
And the jury is told that his words, the words he said to the police officers after the fact, are what made it a crime. And how was the jury to know to go through the process you're just trying to convince us is the correct process?
By the instruction that was given that tells them that they can look, and which is done with the specific intent to arouse or satisfy the sexual desires of either the child, the offender, or both.
That's the intent requirement. No one's arguing about the intent requirement.
Your Honor, I'm reading from the definition of lewd, fondling, or touching.
I'm reading it to counsel. And the first part that talks about, it's separate, and it talks about the fondling or touching in a manner which tends to undermine the morals of the child. There's no intent requirement there.
That's correct.
Which is so clearly offensive as to outrage the moral senses of a reasonable person. No intent requirement there.
That's correct.
Comma, and which is done with intent. Intent is separate from those two descriptions. There is an actus reus required, is there not, counsel?
There is, and
okay.
There was a touching.
And the actus reus just the actus reus does not require any intent. Intent is separate. That's the mens rea, correct?
That's correct. But there's no indication Your Honor, Justice Breyer, the instruction that you're reading from, I think,
That's what I'm reading from.
is the instruction that defines lewd, fondling, or touching. It's not the instruction that defines the crime. It's just defining lewd, fondling, and touching. But it also tells us that we can look at the intent. It's right there. But again, I don't think that's what the prosecutor was doing here. The prosecutor was merely responding to defense counsel's argument. I don't want to confuse the two issues. Maybe I'm committing misconduct at appeal.
I'm not talking about what the prosecutor
Right.
said. I'm just talking about whether the state proved its case.
I think that it really drives it home to me when you think about it this way. There are legions of cases that tell us when you're trying to determine what the intent is, you can look at the acts. It's interesting to me that I would receive pushback by saying if you're trying to shape what type of act it is, you can't look at intent.
If you did not have the testimony or the admission by defendant that was his intent, and all you had was these physical acts, would you be over where Justice Johnson was talking about possibly a battery, or would you still be arguing that we have lewd, fondling, and touching?
Your Honor, if you change the facts, will we be in a different place? I think the answer could be we could be in a different place. We definitely could be in a different place. I'm sorry.
Sorry, you go ahead.
But I still think you need to look at the totality of the actions, the circumstances surrounding the actions, which would be the stranger, and that this guy is undaunted by removing. I mean, if it was just a simple battery, you'd think that you would stop once your victim has been removed. This man moves to the next person and continues to do the same thing. I do think that obviously the case is different if we don't have the expressed intent. But does it necessarily indicate that there's no lewd, fondling, or touching such that we would have only charged sexual battery or something of that nature? I don't know. I can't really answer the question. I'm not involved in the charging process. But I think we do have to take the cases as they come.
How do we... I'm sorry, go ahead.
I was going to say, as I understand one of your positions, it is as follows. Frequently, prosecutors do not have testimony about what the intent was. And what they try to do is infer the intent from the acts that occurred. And you'd have a harder road if what had happened here was a single stroking of the child's head versus rubbing, let's say, the genital area, correct?
Correct.
And what you're saying, I believe, is you're just flipping it and saying, why can't you use the language from the defendant to go back and infer the lewdness of the act? Is that right?
That's correct, Your Honor. I think it's it's a circumstance. It's part of the totality of the circumstances. I don't know why we would exclude that one thing. If we are going to, then we need to have a better instruction for sure that doesn't specifically tell you to look at the intent. And what else are we going to exclude? What other circumstances surrounding the act can we not look at to determine the nature of the act? Where does it stop? I don't know. The case law that I cite from the Court of Appeals in our brief indicates that it's a totality of the circumstances, and I think that the expressed intent, the weirdness of this case is that we have someone telling us what his intent is. You don't usually do that. You don't find that. And so if we're having a little bit of frustration about how we're supposed to deal with this, I can understand it. But to suggest that the district court judge was wrong from finding that the expressed intent was part of the totality of the circumstances, or to suggest that the prosecutor was somehow committing misconduct, ill will, gross and flagrant, by following the instruction and including circumstances that definitely are relevant, is, to me, it just really misses the mark, to say the least.
How do we reconcile the reference to the reasonable person that's in that definition with the subjective intent? One seems to be focused on an objective standard, and your argument, I think, kind of pushes that towards a subjective standard. How do we reconcile that?
The definition of lewd, fondling, touching. I
think
think
I'm
that.
going to agree with you that we need a better definition, perhaps.
Well, I think that I don't see it inconsistent. I don't if someone expresses their intent that they held while they were committing an act, I still think that you can determine whether a reasonable person would have thought that. I mean, I think it's just a circumstance that you add on.
I'm sorry, go ahead.
I wanted to make
I don't know
sure that you two were done with your colloquy before I had a question.
I don't feel like I've answered it very well, but maybe Justice is under a different impression. But I just think I don't see it inconsistent. I just think that while you're determining whether this is an act that a reasonable person would find to be outrageous, or however it's phrased, I think you can look at his intent. I mean, clearly, if you flip this around and the defendant does something and says, "Oh my God, I don't want anybody to be concerned about what I just did. When I walked over to this child, she had a large spider on her rear, and I was brushing it off." Well, they're going to be the first one up here to tell me, "Hey, there's not even a lewd act here. He tells us why he was doing it." That modifies the action. Yes, I touched her bottom, but for goodness sakes, I did it because there was a large spider on there, and I don't think anybody's going to have a problem with that. I'm certainly not.
How do you separate, I think this is where Justice Lukert was, how do you separate what appear to be the different parts of the definition by saying this is done in a manner that tends to undermine the morals of the child, and so clearly offensive as to outrage the moral senses of a reasonable person? Period. If it's, let's say, a simple stroking of the hair, the child may think nothing of it. In this case, the mothers apparently thought something of that plus some other circumstances. But how do you get to that objective part?
Your Honor, I guess I don't understand the question. I'm sorry. I think that the inquiry would be how would a reasonable person interpret the act? And I just can't follow how it's just one more circumstance. The specific intent is just one more circumstance that you add on to help the reasonable person determine whether that act was done in the prescribed manner. It's just one more factor. I hope I've answered the question.
I guess maybe another way to ask it is, how did pushing the hair behind the ear, rubbing, I think one person even used the word caressing the arm, and rubbing the leg, using the words of the first part of that, undermine the morals of the child?
How did it undermine the morals of the child?
Yes.
Well, I think that's an interesting phrase, undermining the morals of the child. I mean, I guess at this point, I can't remember how old the children were, maybe 2 and 3 or 4.
2.5 and 3.5.
I can't recall. I don't know that the child is aware of anything that's happening. If that's the test, then we should change this. I don't know, what could you not do to a 3-year-old child? I mean, they wouldn't understand anything.
And I guess part of the question is when you look at that definition, do you have to satisfy 1, 2, and 3? Or I think you said 4. 4 things. You have to satisfy all 4, or is there some part of those first 3 that are disjunctive?
These are, I think.
And the second?
I think, Your Honor, I think these are merely guideposts for the jury to take into account in determining whether the act meets the act required for the crime. I don't think it's not a step process. In other words, you have to fulfill all 4. It's just something that, because I think it was Chief Justice Nuss that maybe insinuated in one of his questions that if it had been a reproductive organ that was touched, well, we don't really need to go much further than that. It would almost be inferred. But if it was a 3-year-old, I still don't know how a 3-year-old would process that she would understand that something had occurred. I don't think it's a step process.
I think the bottom line is you're asking us to interpret a reasonable person's standard, which we know that we apply in deciding whether this was lewd, fondling, or touching. You're asking us to issue an opinion that says a reasonable person standard can take into account a defendant's statements after the fact to the police officers about what his intent was. And yes, they're egregious, outrageous statements, but how could a reasonable person standard take that into account? Doesn't that assume the reasonable person is visually seeing this happen, and it's what that reasonable person, whether that reasonable person is grossly offended as they see it happening, essentially, not when they think about later what they hear the defendant says to the police officer about what his intent was.
Well, Your Honor, I guess I don't see it as a problem. All I'm asking the court to do is do what I know the Court of Appeals done on a number of circumstances, and that's just to say that when you're trying to determine whether a reasonable person would have been outraged, you don't limit the circumstances. You have them take into account the totality of the circumstances. The reasonable person didn't see any of it happen.
I agree, totality of the circumstances, but the totality of the circumstances you're suggesting includes a statement made to the police after the fact without anyone else present. How does a reasonable person, looking at the totality of the circumstances, look at an expressed intent that came later, after the fact? How is that part of the totality of the circumstances, however outrageous it might be?
It's something that occurred with respect to the crime. It's the same. The jurors didn't see any of this happen. They're taking everyone's word for it that it happened. They're taking the word that it was a caressing of the leg. To me, it's all the same thing. It's a circumstance that happened. I think that the cases that I cite from the Court of Appeals, one of them was a French kiss case, and one of the reasons the Court of Appeals upheld the conviction was all of the background from these people. They'd met months prior. They'd gone on these excursions. They'd gone on those excursions. Those were all things that didn't happen right at the time of the touching as well. It's just the totality of the circumstance argument.
Justice Biles, you had a question earlier. You still have one?
No, you two covered it.
Good. Any further questions of counsel? Thank you, counsel.
Unless the court has any questions, we respectfully request that the defendant's convictions and sentence be affirmed. Thank you.
Thank you.
I am prepared to waive rebuttal.
Is there a second of the motion? Any questions of counsel? I see none. Thank you, counsel.
Excuse me,
Sure.
Chief. You'll concede that your alternative means and issue has been resolved by Brown?
Yes.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. This time the court is in recess for 15 minutes.